Good evening, everyone. My name is Phil Ennis. I'm the Director of Projects for BC Hockey, and this is one of my projects. The program is called the Enhanced Services Program, and this came as an idea from our members, and they wanted some idea of how we could help them over the course of the season in more of a professional development type sense. And what we came up with was a way to run these webinars and that we could reach all corners of the province and bring to you some of the expertise that exists both in our province but here we go. This particular webinar is on identifying and avoiding conflicts of interest in sports-related decisions. Our presenter is Marie-Claude Oslin. Marie is the CEO of the Sports Dispute Resolution Centre of Canada, residing in Montreal, but happens to be out in BC working this evening. So we're very happy to have Marie-Claude with us this evening and look forward to her presentation. She has about 35 years worth of experience in the sports industry and has some very good background. And actually this presentation is a result of some of our members seeing what she could do at a presentation in Vancouver and suggesting that this might be a good topic for the rest of the province to pay attention to. So in saying that, I'll turn it over to Marie-Claude and get on with her presentation.
One can see my slides. If not, just send a chat to Bill, and he's going to try to see what the issue might be. I'm going to talk about conflict of interest in sports. It's a very hot topic, I have to say, since we designed that workshop a year ago. It's been our most popular, so we think that this is something that people need to know more about so that they avoid getting in trouble or creating disputes in their sport organization. So I have a quick presentation plan, and throughout the session I'm going to make reference to some publications that we have, just so you know, because we're not having this in person. You don't get a handout, but all of our publications are available on our website, and you can download them as PDF documents. Some of them are interactive as well. But feel free to visit our website at the end of the session so you can grab the documents that I referred to. Also, when we get to the questions, and what I will do is I will go through my presentation, and I will have a period of question at the end. If there's something that you didn't understand as we were going through and you really need to ask about it to be able to follow, you can type to Bill, and Bill can let me know. Other than that, I know that some of you are probably very tempted in the question period to talk to me about situations that they're either living now or have lived in the past, and you'd like to have some clarity about what could happen, what should have happened. And in order, because we have very little time on this session, I would invite you to keep those questions for you and write me an email, and I can give you my email address at the end of the session, or it's on our website also, and write to me what the situation was about, and I'll be able to probably give you a call back and we can discuss it. Resolution Centre of Canada, I'm assuming not so many of you had heard about us being in existence. If we backtrack 2000, there was a work group that was struck by the Secretary of State Amateur Sport, the Nicodère at the time, and the work group came up with a probable statement that read like, due to a lack of fair and consistent policies or to the improper administration of those policies, athletes and other participants in sports are being disciplined, harassed, and denied opportunities without proper recourse to a hearing or appeal. So the SDRCC was created as a not-for-profit organization funded 100% by Sport Canada, and it was established out of a federal act. So there's actually a law that was passed in Parliament that created the SDRCC. And we do a lot of resolution of sport disputes, mostly at the national team level, but Our interventions in terms of preventing sports disputes are at all levels, and today's workshop is one of our initiatives for prevention. We have 43 professional arbitrators and mediators. They're located around the country, but we do most of our proceedings by conference call or a video conference. So we're really a virtual tribunal. Sometimes we may have an athlete in Vancouver, the lawyer in Toronto, the arbitrator in Quebec City, and us in Montreal, and everybody gets together on the phone to resolve the issues. And we offer services are in both official languages. We also do all the doping cases in Canada. So if there's a Canadian athlete that was found with prohibited substance in his body, his or her, they would have a right to a hearing before an arbitrator, and the SDRCC would provide that. So this is just a picture of the type of cases we do. You'll see that ordinary cases are everything but doping, and they're on a rise, and generally also everything is on the rise. We've had a record year this year of 61 cases, and we actually had to ask for additional funding because our basic funding wasn't covering it. So they're not going away, those disputes, unfortunately, and hopefully it's not because we're bad at doing education. But this is also a slide that shows you how, apart from the doping cases, team selection is our biggest seller. And then we also have carding, which is direct funding to athletes, discipline, and a whole bunch of other issues that can crop up. Just want to talk to you a little bit about the dispute resolution spectrum, because there's different ways you can resolve a dispute. You can go to a trial, to a civil court. It's going to cost you a lot of money. You're probably not going to have a decision until 3 to 4 years from now. You can also go to an administrative hearing, which would be, for example, like a small claims court, so the wait time is not as long, it's not as formal, you may not need to be represented by a lawyer. If you do arbitration, you can come to the SDRCC with an arbitration case. The arbitrator is going to act as a judge and will hear the two parties and decide who's right and who's wrong. We also do mediation and resolution facilitation, and this is the difference between arbitration and mediation is that the mediator or resolution facilitator does not have any authority to render a decision on the case. So he will work, or she will work with the parties to try to bring them to a solution that's going to allow them to work forward. So not dwell on the past, but look at how we can fix things and move forward and work positively in the future. We also have a program, and everything orange is a service that we do offer at the SDRCC. And MedArb would be a hybrid between mediation and arbitration. So the mediator would begin to try to resolve the issues amicably between the parties, and if that was not possible, that person would then go on to become an arbitrator and decide on the issues. The other thing we could do is negotiate. So when we have a dispute with someone, we don't always need the intervention of a third party to come and help, and we can sit down with the person and we can be reasonable people and try to find a solution on our own. So that's called negotiation. And then on the left-hand side of the spectrum, I have prevention. So this is what we're doing today, and hopefully prevention will avoid the disputes altogether, and you won't have to resort to those dispute resolution mechanisms. So, but just as we move left to right, on that spectrum, the cost escalates very quickly. It takes a lot longer to resolve it. It's more formal, it's more complex. There's a greater involvement of third parties, and that means also that you don't have a control over the outcome of the dispute as much as if you try to resolve it amicably. And there's a greater potential for damage in relationships. And this is an important one for sport, because in the sports system, you know, there's so many people, and in a sport organization in your region or in your city, people are neighbors, people are friends, people are business associates, people are clients and of other people they deal with. So, you know, if you can prevent and if you can deal with these issues by negotiating or getting the help of a third neutral party mediator to help resolve these disputes, there's a greater chance you're going to keep the volunteers in the sports system. You're going to keep the athletes in the sports system, and you're not going to get them so angry and upset that they're going to go and volunteer for the Cancer Society. And there's nothing wrong about volunteering for the Cancer Society. I just want to make sure that you understand that. But if they're involved in the sports system, it's because they care. they like sport and they want to do some good, and if too many disputes are making them run away from sport to do other volunteering, then you're losing great resources. So also, as you go from left to right, there's a greater focus on who's right and who's wrong as opposed to finding practical solutions. So the education objective at the SDRCC is developing new content and tools to further inform and educate members of the Canadian sports community about dispute resolution and effective risk reduction strategies. So we have a kiosk that we can go at sport events, presentations, workshops, webinars. The first one we delivered by webinar. It's a good trial for us. And we can consult on drafting policies as well. If sometimes if you're drafting a policy, you may have a question about certain parts of it, and we can read it for you. And those are the sample topics that we can cover other than the conflict of interest. So quickly, this is all of our publications on our website. So you go to our website after the workshop and grab everything you think is relevant to you. And call us if you have ideas of other things we should develop. One of the things, and I'm going to go back to this, we have a document that's called Main Causes of Disputes and Prevention Strategies. And over the years, and I've seen 425 disputes since I started working for the SDRCC in 2007, I think that was. So I've seen a lot of them, and what we've noticed is that there's some trends, and there's about 5 common causes of disputes that are at the origin of cases that come to us. And one of them is the decision maker being in conflict of interest, or the decision maker being perceived to be in conflict of interest. So that's what we'll try to avoid today. And if you look at the things, the round circles are around, it looks like a flower, but at the top there you have 3 strategies that will help you avoid conflict of interest in your decision-making processes, and we'll talk about all of those later on. So that was my introduction, and now I'm going to really start talking about the subject matter of the day, which is the conflict of interest. So on the right-hand side, you have a picture of a publication we have on our website. It's actually it's a leaflet, and it opens up into a poster. It's a poster-sized document when you open it all up, and it guides you in deciding whether you're in conflict of interest and what you should do next if you think you are. So, what is a conflict of interest? Well, this is a definition. There's many of them, but it's very representative of what we're trying to teach here. A situation whereby an individual has a private or personal interest sufficient enough to appear to influence the objectivity of his or her function as a decision maker. So when I refer to conflict of interest all throughout this presentation, this is what I'm referring to. So it's a situation whereby an individual has a private or personal interest sufficient enough to appear to influence the objectivity of his or her function as a decision maker. All right? I don't know if anybody's writing this down, but I'll move on to the next slide now. So we have different types of conflict of interest also. Sometimes they can be real, they can be potential, and they can be perceived. And I'll give you different examples of that. So a real conflict of interest is when the decision maker does have a significant interest in the outcome of the decision. And when it's a potential one, the decision maker could have a personal interest in the outcome of the decision if, and then there's 3 little dots there, because it depends whether or not that situation arises or not. And I'll give you an example of that. So the decision maker has a significant interest in the outcome of the decision. Let's say that let's say that I'm a volunteer on the board of the Hockey Association, and I happen to work for someone who manufactures equipment. And the board is looking to strike a deal, or maybe negotiate a sponsorship with my organization for the hockey players in the group. So if I sit as a board member in a negotiation, I'm also sitting in as someone who may benefit from the negotiation as a business person. So I have to be very careful now because I can't be wearing both hats in the negotiation. I have to decide. And obviously I would have to go on the business side. That means I cannot be sitting in a room where when the board is discussing whether or not they will go ahead with this deal, whether they will negotiate a little harder, whether they will ask for some more, maybe more benefits to their club or their association. Okay, so that's a real conflict of interest. The other one is a potential one. The decision maker could have a personal interest in the outcome of the decision if. So let's pretend I am a provincial team coach, and my son is actually a pretty good player, and there's a good chance he's going to be in the age category to go to the Canada Games this year. And so there's a chance that my son will be a person who will try out for the Canada Games team. And so I am not in conflict of interest yet, but if I do, if I sit on that committee that decides who's going to be on the provincial team to go to Canada Games, and my son is one of the candidates we're considering, then I am in conflict of interest, but only if my son is actually trying out. If my son decides halfway through the season that he's going to quit hockey and is going to do something else, then it's not a conflict of interest anymore. Or if my son is injured at the time and will not get back on the track before the Canada Games, he's out of the race, you'd say, and that way it's not going to be a conflict of interest for me. So you can be in a potential conflict of interest if you are in a decision-making capacity that, depending on circumstances that may or may not arise, you may have a personal interest in the outcome of the decision. Okay? Hopefully that's clear, and I don't know if Bill gets any question from that, but we'll plow through. So the other one is the perceived one, and it's the decision maker that seems to have an interest in the outcome of the decision. And sometimes from the outside, viewed by a third person that has nothing to do with the situation, it might, you know the smell test. Sometimes it just doesn't smell good, and when you're on the outside, you don't know this, but you see it from the outside and say, I wonder what happened there. There might be something wrong. Once you find out about the facts, you may find out that everything was done properly. And I'll give you a quick example of that, and I'll use a figure skating one. Let's pretend that I'm on the board of a figure skating club, and there's some lady on our board who's really, really good at sewing, and she's actually interested in being the person who's going to make all of the costumes for the skaters. And when we go into a call for proposal, and her company or herself personally pitches in one of the proposals. If we do award to her, eventually, people on the outside are going to say, oh, of course, she was on the board, so they gave her the contract. But what you need to look at is what took place actually before they awarded the contract. Was she removed from the discussions from the board meetings? Hopefully she did not see any of the proposals that were sent out by competitors, and she was not given any information about the other bids, and her bid was considered on its face value in terms of how much money she was going to charge and how quickly she was going to make the dresses and so on. So from the outside, it looks fishy. If you investigate and you find that they've done a proper job at managing the conflict of interest, then it's not one. But but the perceived one is a smell test, really. That's what it is. All right. So I'm going to play a little game with you now. There's a myth of reality. I have about 10 or 12 statements that I would like you to type for Bill to see. If you think it's a myth, type M and send it as a chat. If you think it's reality, send an R, okay? And then I'll give you the answer anyway afterwards, but I just want to do a little test here of what people think it is. So myth or reality? People are in conflict of interest. People in conflict of interest are great people. Is that a myth or reality?
Reality.
Okay, well, you guys are good, and ladies too. Yeah, it is a reality, and one of the things that happens in the sports system is that people in conflict of interest are often the best ones, and why is because they wear several hats. So it's the parent that you want on your board because he's really good. It's the parent that you want on your coaching team because he's a really good coach, and it's the person who's got great contacts in the business community because you know, it's going to be good for your finance and sponsorship. So often people in conflict of interest are found in that situation because they wear several hats. And the reason they wear several hats most of the time is that because they're good. They're good and you want them sitting on committees and doing volunteering for you. And one of the things that you can keep in mind too is that there are some people who will, you know, consciously put themselves in a position where they can gain advantage either for them or a family member. They're not the best people, okay? So some of them do this consciously, and some of them will end up in those situations by default. So, all right, the next one is declaring a conflict of interest is an admission of guilt. While you, all right, where are you getting, Bill?
Mostly myths.
Okay, and we have a myth. It's true, if you declare a conflict of interest, it's not that you're guilty, it's you're avoiding to be guilty. So you want to declare a situation that you believe is important for others to be aware of, and therefore they can decide whether or not it's appropriate for you to continue to act in a decision-making capacity. The next one is pointing out a possible conflict of interest is an accusation. Myth or reality? Bill?
Mostly myths, but a couple of realities.
Oh, okay. No, it's actually a myth. If you point out a possible conflict of interest, you're just raising your concern, and you may find out, and this is the example I gave you about the perceived one, is you're sitting on the outside, you may say, I wonder if there's a problem with this, and you're asking a question. So I think it's fair that you would have people saying, you know, Bill, is it appropriate for you to be part of this discussion? You know, we're talking about your son getting funding or not next year. So it's not, you're not accusing him, you're reminding him that maybe it would be appropriate for him to step out while we discuss this particular issue. So it should be part of the normal procedure, and of course, you know, we take for granted at this point that people know what a conflict of interest is, which is not always the case. So there's going to be some education necessary among your membership, and we'll talk about that as well afterward. So the next one is a conflict of interest is not only financial. Myth or reality? Bill, a verdict?
Reality.
Yeah, reality. Yeah, it is. And what's happening here is that you can have a conflict of interest that has nothing to do with money. It could be friendship, love, envy, ambition, family, any personal or professional interest that doesn't necessarily put money in your pocket, but that's going to give you maybe you know, something else that you need from these people. It doesn't have to be about you gaining financially from being in a conflict of interest. And the example is being on the selection committee for your son trying out for the Canada Games. It's actually going to cost you money if your son makes the Canada Games team, especially if you want to go and see him play or bring your wife or other people along, or husband. And so, you know, it's not always about whether it's going to bring money into your pocket, but it's whether it's going to bring you other benefits from the decision going one direction or another. I can still remain objective. Put quote marks on that one. So is it a myth or reality?
More myths than realities.
Okay. It is definitely a myth. And one of the things is that if you think you can remain objective, you're not. Your concern about not appearing biased may cause more harm to people you care about. And I'll give you an example of that. If you coach a team where your son or your daughter is playing, you may end up being a little harsher on them just because you want to show that they're not getting favor treatment. So, and you can just to make sure that people on the outside know that you're not giving them any favors, you can be harsher on them, and that's not, it's actually doing a disservice to justice, because you're going to go further out the other way to try to avoid being
almost all reality.
okay. Well, here's the interesting part. It's a myth, and I'll explain to you why. If people affected by your decision consent to you remaining in a decision-making position, it's possible that removal is not automatic, and it will depend. And I'll show you later on how, depending on the degree. And I talked about the different types of conflict: the perceived, the real, and the potential. And those are types of conflict. The next slides are going to show you how you can have a different degree of conflict. So there's conflicts that are at one end of the spectrum that you can't just stay in your decision-making capacity, and there's some others that are not so damaging to the system. And one of the things that you have to think about, sometimes in a very small sport community, your best person might be someone's father or mother. And if you believe, and if the athletes believe, and the other parents believe that it's still the best person to make that decision because of the expertise that they have or the experience they have, then there's possibility for people to agree that this person will continue to act in the decision-making capacity despite a possible conflict of interest. But it's important for the people on the potential losing end of your decision to be aware of the facts, be made aware of the facts, and tell you it's okay, I still think you're the best person. We do this at the SDRCC as well. When we have an arbitrator that is sometimes selected by the parties, or sometimes appointed by rotation if sometimes the parties fight so much about everything that they can't even agree on an arbitrator. We have the arbitrator check who the parties are, who the lawyers are when there are lawyers, who the federation is, who's representing those people, and making sure that their law firm, if they're lawyers, their law firm has not dealt with any of those as clients, or that those lawyers have worked on cases with them or their colleagues before. So they do an independence check. And sometimes they will raise, and I'll give you a funny one because I think it's just a funny one, but some people are more sensitive to what a conflict of interest is than others, and one of them a few years ago was, you could tell, was highly sensitive to what a conflict of interest might be. So the arbitrator reviewed who the parties were and the lawyers were, and she recognized the name of one of the lawyers, and she declared on her Declaration of Independence that over 40 years ago, when they were in law school, they had an affair. So, the funny part of it is that the lawyer maybe, and we're not even sure about that, maybe didn't even remember about that. But she felt it was necessary because she didn't want later on people to say, oh yeah, of course she decided in favor of one or the other because, she knew him in law school, and I know that they had a relationship. So, people have a different degree of sensitivity to conflict of interest. If you're not sure, you might as well declare. And most of the time, I suspect that people will say, look, I trust you to be the right person to make the decision. Please continue on. Okay? But it's not always automatic, and you have to make sure that the parties and the people affected by your decision will consent to you continuing in your role. So that's the last one. It's all about honesty. Myth or reality?
Reality.
Gotcha. it's true that there's something about honesty. You don't want people to hide information that might disclose a conflict of interest. But I say most of the time it's about knowledge. It's about people not even realizing that they are in conflict and that they should declare it. So part of what I'm going to talk about is the importance of you communicating to your members what is a conflict of interest and when it's appropriate, and provide them with a proper process to disclose prior relationships, business relationships, or family relationships that they may have with people who may benefit or be on the losing end of some decisions that will be made by them. So and I agree. I'm not saying it's not always about knowledge. Sometimes it is about honesty, and sometimes people, as I mentioned before, do it on purpose. You know, thinking that sitting on the board or being a coach will guarantee that their son or daughter will make the team. So we have to be careful about that. But most of the time, I would say it's all about knowledge, because they didn't even realize that they should have said something or done something about it. Right. So we're going to talk about what to do in terms of when you realize that maybe there is a problem. So when I talk to you about the spectrum, there's actually there's a range of severity of conflict of interest. The green list is facts that are not considered objectively as a conflict of interest but warrant caution. So you may want to reveal the information if you want to be extra cautious, although at that point it's not necessary. If you want to see some examples, the poster size document, and you can go to our website and download it, and you'll see examples of what fits under the green list. So it's not necessarily to disclose, but it is preferable because it's going to show that you're sensitive to that, and you want to make sure that people don't accuse you later on of having hidden facts from them that might have been important. The orange list would be situations that could create a perception of conflict of interest among the person affected by the decision. So if you have someone on trying out for a team who ends up being cut from the team and turned out that the last person to make the team was the son or daughter of one of the coaches, that's a difficult situation to explain. So the orange list would call for you to disclose ahead of time, before making that team selection decision, and if no one objects, continue to act as decision maker. So if all the, and I would say in minor hockey, you might want to involve the parents in giving their consent to that. So they you know, it's a parents meeting. It's a, look, I know we haven't made up our team yet. You know, Joe is Stacy's father. Stacy's trying out for the team. Is everyone comfortable with Joe being part of the decision-making process? And if they all say yes, then Joe can remain a decision-making. But if not, then maybe when it comes down to the tough decision, Joe is going to have to sit out and let the assistant coaches be part of that discussion on the last. So it's difficult to manage. I know this because we, and I say we because I'm involved in a swim club, and we rely heavily on parents to be the volunteers and the coaches and the officials in our sport community, and you can't exclude everybody automatically. But one of the things I would encourage is people to be open about it, and making sure that people don't find out after the fact that, oh, I didn't realize he was the father of Stacy, and you know, should he have remained on the decision-making group. Or you could decide right away, and this is a red list, a serious conflict situation, but less serious than the next one I'm going to talk about. So it's in relation to the other. But the red list is if you don't get express consent from everybody who could be affected by your decision, then you have to step out voluntarily. At that point, you need to disclose your relationship with the people about whom you're going to make decisions, and you have to have everybody expressly agree to you continuing to act as a decision maker. So some of those situations are, for example, the too close for comfort ones, and I've come back to the example of the daughter or son on the team. That would be a red list, actually. I would say that would be a red list, and if everyone, I gave that example earlier, but if everyone was okay with you continuing because you are the best person to make that decision, ideally get that in writing, right? Because what happens in meeting doesn't always stay in the meeting. So the inflexible red list is at the far end of the spectrum, and this would be the situations that raise the most serious concern about impartiality. And I talked about the bidding for a contract and so on. If you're a business person and your company is bidding on a contract, you can't sit on the board at the same time. This would be an automatic. Don't even ask permission. Just step out and declare a conflict. And so it's very important at that point to not even stay there. These decisions, by the way, made by people in conflict of interest, they could actually be overturned in civil courts. And you have parents or parties who have enough money to take you to civil courts over this. You'll spend a lot of money defending yourself, or your decision will be overturned. You'll have fingers pointing at you. You'll have a judge telling you how a bad person you were for staying in that position. So you don't want that, and certainly you have to be very careful. So if you look at the publication on our website, you'll see some examples of situations that would be in the inflexible red list, where you actually absolutely have to remove yourself from the process. I see time flying by at 7:42 already. I have a few more slides, and then I also have sample cases that came to the SCRCC. So one of the things, if you had committed to be only here for an hour, I won't be offended if you have to sign off, but if you want to stay for a discussion on those cases, then I'd be happy to stick around a little longer. So the next one is, what do we do then to prevent that? So other than removing yourself when you're in conflict of interest or declaring the conflict, is you need to make sure that you have a clear policy on conflict of interest in your organization. And one of the things that it's going to help is make sure people understand what a conflict of interest is and what's the process for them to declare and to disclose and to step out when it's appropriate. So the process is, the policy is not necessarily meant to be a disciplinary policy. It's a policy to educate your members about proper mechanisms to deal with potential conflict of interest. So you want to use this to train your new members, your new board members, and the volunteers that will act and be in decision-making capacities. You want to make sure that they understand that your organization has a conflict of interest policy, and that there are certain precautions that they need to take along the way when they're in decision-making positions. So you have to create an atmosphere where members feel comfortable declaring the situation. And again, I'm going back to the myth of the accusation. And it's not when people notice that there may be something inappropriate, it's not necessarily an accusation that you're making. You're just you're asking the question. Whether or not it's appropriate for this person to continue. And you may find that the answer they're going to give you is that it's okay because everybody affected by this situation is aware and has already agreed that this person continues. But you have to create that, that atmosphere in your sport organization where people don't feel bad about declaring the situation, don't feel bad about saying, it's not appropriate for me to continue. You could provide a simple form that they need to fill out. We do this with our board members all the time. When they join the board, they need to and even our arbitrators, before they join the rotating list, they have to do this. We're giving them a form, and they need to declare whether they have any ties with potential parties. Board members will have to declare whether they sit on national sport organizations, maybe, or they're involved with multiple sport organizations. So they declare that ahead of time. So what it does is it just gets us to have our radar on, you know, and when a situation arises, we know so and so has been, you know, is still a board member of Swimming Canada, and we have an issue that involves Swimming Canada that needs to be discussed at the board level. That person is going to step out. One of the things we do too is we add it to the meeting agenda. So our board meetings have, you know, the welcome from the president. You have the adoption of the agenda. You have the adoption of the minutes from the last meeting, and then you have the declarations of conflict of interest. And what it enables the people is that sometimes you're not always in conflict of interest. By the way, it's situational, right? It's a situation. It's an agenda item that it's not appropriate for you to be discussing, but that doesn't mean you're in conflict of interest and you have to leave the meeting entirely. So what you're going to do is you're going to look at the agenda and say, if we're going to be discussing that particular thing at one point in the meeting, I should be removing myself from the discussion. Okay, so it's just a flag at the outset of the agenda, because it is, again, it's situational. It's fact and circumstances that that are inappropriate for you at this time to be discussing as a board member. Okay, so the next one would be control mechanisms or approval involving several individuals, and this is really hard for someone to claim that a decision was made with bias or in conflict of interest if there were several individuals involved in the decision. So if you have a single coach making a decision versus having a coaching team, or you have a team selection committee or high performance committee, and sometimes you can have a high performance committee recommending to the board of directors, or you can have the head coach recommending to the high performance committee. So those very important decisions that have the potential to be contentious, you would want them to be made in a process that involves several individuals. Either it's a committee or a grouping of people, or it's a recommendation that is approved by a higher authority. Yeah, so that's kind of repeating it, but decision that can be made by a group of people rather than just one individual, it just reduces the perception that you know, the decision was slanted in one direction because of that individual having too much power. You can call it that way. So the other one is to play it by the book, and we say decisions complying with policies and rules. So if your decisions are respectful of the policies and rules that were adopted by your board or your club or your association, then it's really hard for someone to say, oh, of course you were in conflict of interest when you made that decision. So if your decisions are justified by facts, and if, for example, in the disciplinary case, you have a no tolerance policy on certain actions that may occur on ice, and you have a disciplinary committee that reviewed the video and determined that there was an infraction to the code of conduct, and in the code of conduct, you know that that warrants, like if a player does that, it warrants 5 games suspension. Well, you've done exactly what the policy says. Even if someone may want to accuse you of conflict of interest, even if you were going to ask someone else, completely different, to make a decision on the same case, they would come with the same conclusion because your decision was compliant with the rules and policies. Where you have to be careful is when you have maybe clauses in your policies that give some people discretion to make exceptions to the rules. Those situations are to be dealt very, very delicately in terms of making sure that the person who has that extra discretion to overrule a policy or to make an exception to a policy don't have a conflict of interest. So you want to have decisions that would be the same no matter who decided, and that's going to reduce the chances of people claiming that there were conflict of interest in the decision-making process. All right. So we're at the stage where I'm quite happy, actually. I'm non-conflict of interest policy that can be adopted and adapted by sport organizations of all sizes. So hopefully, and you're welcome, Suzanne. So that's great. Thank you for attending. I'm happy to have been invited and honored to be invited. And if you have any questions, please do not hesitate. You go to our website. You can go under who we are, about is the RCC and staff, and you'll have my email address and you even have my cell phone number. Just be mindful, I'm normally on Montreal time, so I'm 3 hours ahead. If you need to call me, I would prefer if you aimed for the business hours in Montreal, and I'd be happy to entertain more questions or maybe more personal.
Mary Claude, on behalf of BC Hockey and everyone that attended tonight, thank you very much for taking the time and all your expertise on this topic. I think I'm always astounded by the expertise that we're surrounded with, and just need to find a way to take access to these people for the benefit of our own programs, and you are certainly one of those. So good luck in the future, and thank you very much, and I hope we will have the opportunity to use you and the people that you work with expertise in the future as well.
Yeah, I'd be happy to. Just look at the list of topics that we can cover, and we'd be happy to come back maybe next year.